Schuyler Moore, excuse me, partner at Greenberg Lusker, a 100-person law firm in Los Angeles. I've been practicing for 40 years in the entertainment industry. I'm the author of a book called The Biz. That's very popular. It's in its 5th edition right now, 6th coming out, and it covers the industry. I've been an adjunct professor at the UCLA Law School, the UCLA Business School, the USC Law School. I have a regular Forbes column. I have a YouTube channel under Schuyler Moore.
So Sky, let me jump straight into the subject, which is the artificial intelligence has affected or influenced the strike that has been characterizing these last months in Los Angeles and in the entertainment world.
Well, AI is going to absolutely impact the industry in every single way. It's got the ability to go right from ground zero to finished product, including writing the treatment, writing the screenplay, doing the visuals. It can create characters. It can create music. It literally has the ability to. I have a client that is right now working on creating entire films from ground zero with AI.
So, being lawyer on both sides, I guess, for the authors and for the producers, what key elements would you suggest to be inserted in the contracts?
Well, it's critical now to include a contract clause that says that clearly delineates what has been created by AI because of the recent U.S. Copyright Office case that held that AI created material is not protected by copyright. And all the current contracts have reps and warranties as to the ownership that it's original work, it's protected by copyright, it's not in the public domain. And so that's going to have to change. So what will now be, you'll have to say, other than these paragraphs or this section or this part of the film or whatever it is, whatever content you're licensing, you will very definitely have to clearly delineate that that's created by AI so that whoever's buying it knows they're on alert that portion is not protected by copyright. That's really one of the key issues. Another issue is whether you prohibit it completely. You just say, hey, you can't use AI, period. Whatever you're doing, whether you're a writer, director, whatever, you can't use AI, so that we know that we don't have that problem.
But then how would you control it?
Well, that's always a problem. There are applications that reverse engineer to determine whether something was created by AI. It's an arms race, of course, that the better that gets, the better the AI gets. It's not easy to tell. The short answer is it's not easy to tell. And there's going to be a lot of litigation down the road on a lot of these issues. Like, for example, when you go to register something in the Copyright Office, my prediction is that most people will use the I forgot theory. And, I forgot that I used AI, and they'll register it in their name and worry about litigation later. That's, as a practical matter, what's going to happen. And both on the contract side too, they'll say, oh, I didn't use AI, but oh, by the way, I forgot.
So you mentioned UCLA. Back in the time, I studied copyright law on copyright of the 90s, I guess you know very well. And there was an example of trying to defer what is not copyrightable and what was. And it brought the example of a photocopy of a Xerox. If you just do a Xerox, there's no added value, no creative value. And if you sort of change, you add some sort of creativity, then you may assume, if we were to step in the shoes of the judge, that if the AI is used as a tool, it's like a sort of a very sophisticated pen. And therefore, whatever is realized, created by the AI, is still a longa manos, a stretched arm of the author.
There's a push to get AI copyright protected, period, full stop. So that there's one whole group of people that are pushing to get AI copyright protection. Next is what you're arguing or what you're mentioning. Where's the boundary? Everyone's saying, oh, this is like Photoshop. This is like, some minor edits that I did it. I used AI as a tool. Exactly what you said. I used it as a tool, but it's my creation. So people are trying to push the boundary of that. And as the court said, actually, in this recent case, this is going to be hard. That case was very clear that it was just clearly AI. But boy, you're right. Where's the boundary? And that is not going to be an easy determination at all. By the way, at all. I want to address one other thing that you are alluding to. Really, when you talk about changing it somewhat, taking an existing work and changing it somewhat, that's a fair use question.
Right.
And the question is what you did you change it enough to be fair use? And this one's important because the analysis used to be, when you were in school, when I was in school, the analysis was it transformative? Did what you do change it enough that it's now effectively protected by fair use? That analysis is gone now. So you and we have to go back to school on this one because of a recent Supreme Court case in the U.S. Dealing with Andy Warhol took a photograph of Prince and colorized it. And the court threw out the transformative test and said the new test is it's competing use. Would the owner of the original work have charged for what you did if they knew that was actually going to be done at the time? So that changing it a bit, colorizing it, using AI to manipulate it no longer is a defense. No, transformative is out. So it's now a competing use test. And so where this comes up on AI in a huge way is the output. If you look at the output, if it's similar to some existing work, you can no longer say, well, I changed it and it's transformative and therefore it's fair use. That no longer applies. It'll now be, is it a derivative work or not? And if it's a derivative work, you've got problems. Now that goes back to that's a similar question of, are the works so similar that they are in fact derivative works? And that's just I always tell everybody that's the courts rule with their heart on that. That is, if you show the court two works, here's work one and work two, what do you think, judge? You think they're too close? And the judge rules with his heart. And if he thinks they're too close, he says, that's a derivative work, and therefore it's infringement. And if he thinks they're far enough apart, then he goes, it's not a derivative work. It's not based on the original, and therefore no infringement. So that you still have that fundamental heart test, but now it's on the derivative work as opposed to the fair use test.
With the artificial intelligence-driven deep fakes becoming more sophisticated, what legal measures are in place to protect celebrities and public figures from unauthorized use of their likeness?
All right, so this is a fascinating issue. What the actors can bring in the U.S. is called a right of publicity claim, and even their estates, if they've died, they can bring in general a right of publicity claim. However, there are a lot of court-developed defenses to a right of publicity claim that, in my opinion, are just outright wrong, but they are absolutely out there. Some courts say, if it's an expressive work like a film, then it's protected by the First Amendment against a right of publicity claim. And I think that's nuts, but some courts do that. Some courts say, well, if it's transformative, now remember that word from copyright, they now have imported it into right of publicity,
right?
And that same, is it changed somewhat? Did you change his image a little bit? And by the way, I think that transformative test still right now exists under right of publicity. I believe that it's going to get thrown out there, just like it got thrown out by the Supreme Court for copyright. I believe that the transformative test will get knocked out for right of publicity, but right now it's there. And then you've got some courts that say, copyright preemption. If whatever it is a copyright work, that preempts a right of publicity claim. Again, I think that's nuts. But so you've got this whole chain of defenses, including some statutory, like there's for deceased actors, you're allowed to use their image, like Marilyn Monroe. You're allowed to put her in a movie. In California, New York allows that. Because it's
the estate to oppose to that, it's easier, isn't it?
Yes. And then we have in the U.S. we have this whole problem that all the states have different rules, and it's totally unclear. You end up with forum shopping. So you end up looking for the best jurisdiction for what it is you're doing, because the laws differ state by state, both statutory and the courts. So you got to really be careful where you file your claim so that you don't have all the if you're a celebrity, you don't have all these defenses that might apply in some states, and so you hope you pick one where you have the claim. But bottom line is it better. I'm actually advocating for federal legislation that gives carte blanche, right of publicity claim across the country for exactly this issue, for exactly this issue for AI.
A sort of a blanket ruling over all the disputes.
My goal is should be federal legislation that says you got a right of publicity, and all these stupid case law in the U.S. gets overridden by federal legislation, and very clear that the celebrities can sue, and with their images being used on AI. Period. I mean, that's got to be the case.
Yeah, I was at a meeting this morning where there's a software with Denzel Washington's face speaking in Italian with his own voice. I mean, the software.
It's out of no, it's out of control these days. There's a whole show. There's a show called Reality Deepfakes from the UK. They're just in your face using celebrities and putting them in quote reality shows and having them do absurd things. And it's we have clients that are celebrities that we have this problem now with how we're dealing with it. And
I guess for us lawyers, there's going to be a lot of work to take on.
Lots. Oh, you can't even believe on every single issue. I mean, I can go through some of them, but we've only touched on what's coming. Yeah.
And internationally, do you feel that because Europe looks very much towards the US as the first ones to take the US courts, the first one to take decisions because they're upfront, they're dealing with copyright issues much earlier than the European ones, and also because it's not a codified system, but it's a system based on precedents. What do you think would be the influence towards the European laws in terms of copyright ownership and regulation, especially international regulations, if any? I mean, even over the Berne Convention, there's been fights for centuries.
You're exactly right. I mean, all the courts of they look to other courts for interpretation. The U.S. does as well, by the way. We often look to the UK or to Europe, and. Yeah, hopefully there'll be hopefully there'll be some uniformity, but it's going to take time, and by the time it's done, there'll be something else that we'll be fighting about. But no, this is it'll take time. I don't know how far Europe will go. One of the issues in Europe is that they've got droit moral where we do not have that in the United States or some countries in Europe. That adds a whole different flavor to it, including on copyright. So you've got that issue, which in a little bit has spilled back into the U.S., but on very, very little.
That's the heritage of the Napoleon copyright.
Yes.
And when the Americans enacted the copyright federal law, enabling to copy rightfully, as opposed to the right of the authors, which considered the copyrightable work as a property of their own. Let me drift carefully to the matters concerning the SAG and WGA, because there's a lot of confusion going on over here. The news that we've just received is that there is a meeting point between the contradictory parties. What is your take on this? I mean, first of all, it's better to explain why the residuals were the core of the fight.
Oh, well, the residual, I think AI is the core of the fight, by the way. Really? I think AI was,
I thought that was the excuse, because really the authors are blaming the fact that they don't get enough payment. And so they're always waiting for residuals on the various passages. And my interpretation was because of the platforms never disclosing their internal algorithms, saying how many times a show goes on, the authors, poor guys, never know how much they earn.
That is correct, but I will tell you the bigger fight was AI, because that was existential. Because the issue is, can the studios just replace writers with AI? Period. I mean, that's clearly theoretically doable, and that was a much more bigger threat. Forget residuals. I mean, you could just cut them out completely.
Oh, okay, so that was basically the blanket excuse, but really the fight is against the robotic system.
It's both. You're right. I mean, streaming, absolutely, that was a big issue. But the AI, I actually think was the bigger. That was
as an advice to lawyers who draft contracts, what would be your advice and carefulness that you would suggest in drafting or reading or interpreting? Because obviously, I mean, every time that I'm drafting a contract, I read the differences between US and European contract. Basically is when you assign rights and you have to list all the rights, and there's always a last paragraph and all the media known or unknown. Well, now there's augmented reality, virtual reality, and even giving away rights of, you know, camouflaging or using the parts of the face and reenacting.
Yes. No, exactly. You have to look, but that's been the case for. You have to be very careful, obviously, on that. What's called the residuals clause about residual rights. Who owns future media? As you say, is it the metaverse, virtual reality, you know, augmented reality, AI? So you have to be very careful on. There are going to be a lot of fights on who owns that. That's just like there was when video came along, and just like when streaming came along, where we fight forever about who owns that. So yeah, we'll be fighting that battle for sure.
It's no surprise. I remember when I was at UCLA and I was reading first contracts where it says not all the world, but all the universe, and we all had a laugh.
Right.
Well, it's not so laughable. I mean, Elon Musk is now considering to populate Mars. So
yes. Yeah. No, that's true. That you have to be careful. Yes. Well, one thing I think that's really worth talking about on the AI side is in the US now, there have been an absolute avalanche of lawsuits by existing content owners saying that you can't use that to upload to the AI, because AI is, of course, whether it's large language models or large visual models, it is absorbing everything that's out there now and then creating something else, okay? In the process of using everything that exists, they're copying that. Whether one way or another, they're copying it and uploading it into the computer. There have been all these lawsuits by every owner of music, books, print, photo libraries saying you can't do that. All right. Now, what's interesting in the US is there was an older case, Google versus like Library Association.
I remember it.
Where Google, right? Remember that? All right. Where and everybody has been saying, aha, that allowed fair use, and therefore that what the AI computers are doing is fair use. All right. I'm going to go out on a limb, and I will predict that will not be the case because of this case that I mentioned, the Andy Warhol versus Prince case. Because if you accept a competitive use analysis now for fair use, which is now the test, everyone who owns content does want to get paid, expects to get paid, is saying loudly and clearly that they expect to get paid, and doesn't like what's happening. And therefore, I think that is no longer fair use, and I think that that's going to be copyright infringement, and that there's got to be some way to compensate the people who own the existing content. And then the question is, what is the outcome of this huge battle? And I think that the outcome is that ultimately there'll be some sharing of revenue on some fractionalized basis. And in fact, AI itself can figure out how much of the output came from whatever input, and that sooner or later there'll be some allocation of compensation from the output to pay the people on the input side. And that you know, that's the only way that I can think that this would ultimately, that issue will ultimately shake down. But it's huge. I mean, this is, there's new litigation every day on this in the U.S. Every day.
You mentioned federal regulation, which I think is the necessary solution to a jungle of controversies. Let me extend the thought to the platforms. The platforms are doing a huge amount of money to the detriment, obviously, of the authors and perhaps even the actors. I don't know. But do you think it would be needed a law which regulates their internal algorithms so that they disclose the amount of times that a film goes on air? But by the way, Netflix knows perfectly well how many times you and I see a movie, and if we've fixed it or not. Why don't they disclose that?
I have not yet read, because it just came out, the WGA agreement, but it might be in there that, you know, for the first time there was a proposal by the studios that they would disclose that information to the guilds for the next round of negotiation. I do not know where that issue came out, but I don't think this is a federal legislation question. I think it's going to be a contract arm wrestle question,
Right, yeah.
and it may have just been resolved in the WGA agreement. This is a key issue. I'm going to have to go look. I will tell you offhand, just from the quick summary I read, it does not appear to have been resolved. Because otherwise it would have been like front page big news and and I didn't see it. So I don't think that. I tell you what is pending on the federal legislation side, though, is that SAG, the Screen Actors Guild, has and the recording industries, various groups that own, whether it's celebrities, images, right of publicity, all the content owners have gone to have put in requests for federal legislation to stop AI from using either A, celebrity images, or B, copyrighted material. And so that's pending in the Senate. It is this is debate. No, that's along with mine, which is the right of publicity one. This is a big issue whether federal legislation will get passed, but that's one thing. SAG in particular is trying to fight that. They're also trying to fight it in the current SAG negotiation. Obviously, they could stop it by contract. They could say, "Hey, studios, you agree contractually, you will not modify actor images, but more importantly, you won't create new ones." And that's the bigger issue. The bigger issue for SAG is the creation of new images. So I mean, forget modifying Brad Pitt. Who needs who you could literally just create a new Brad Pitt, but a handsomer. That's a bigger issue.
Absolutely.
And they're trying to stop. I mean, that you have to stop with contract if you stop it at all.
Wonderful. Sky, thank you very much.